Hello, everyone. I want to talk to you about judicial review for a few minutes here. This is one of the key concepts for the class, and I hope you have some idea already about what judicial review is, but just to make it clear, it is the power of the Supreme Court and of the federal judiciary as a whole to review laws to see if they fit with the Constitution. State courts, like the state Supreme Courts, can also do this with state laws. And so the idea here is that the Constitution is, in a sense, applied to the laws to see if they violate the Constitution. And if they do, then it is, that law is null and void. That's the idea of judicial review. Okay. Now, it's not explicitly stated in the Constitution. Article 3 of the Constitution is pretty short. It's not a whole. There's not a whole lot of detail about the courts there. Not very much about the Supreme Court in particular. It does say what the jurisdiction, in other words, the matters that come before the Supreme Court are. It says what the jurisdiction is, but and of the federal judiciary. But it doesn't say explicitly that judicial review is one of their powers. Now, in the Federalist Papers, number 78, Alexander Hamilton does make the argument that indeed this is part of the Supreme Court's job. But there have also been those who disagree with that. Now, I'll give you some examples of judicial review. And the reason I'm talking about this in the readings for this week is that you have a number of examples of judicial review in chapter 3. Okay, the authors of your textbook want to talk about federalism. Okay, this idea of layers of authority, or the federal governments and the state governments are in some sense sovereign, and there's kind of this dual sovereignty there. But how that actually works out is not entirely spelled out in the Constitution. And during the early 1800s, there are several cases like McCulloch versus Maryland and Gibbons versus Ogden that are described in your book that set the boundaries of what the federal government supremacy means, what it means to have this federal relationship between the states and the federal government. Okay, and those kinds of decisions are examples of judicial review. Okay, so when the government of Maryland decides to tax the Bank of the United States, okay, because the government of the state of Maryland is controlled by people who don't like the Bank of the United States, they try to tax it, and John Marshall, the really important Chief Justice early in the Supreme Court's history, the early 1800s, says you can't do that. Okay, the power to tax is the power to destroy, and the federal law is supreme, okay, over the states. And so they can't attack a federal institution like that, all right? That's an example of judicial review, saying, no, sorry, state of Maryland, you can't do that, okay? No matter if it was passed by your legislature, signed by your governor, all this kind of stuff, you can't do that, all right? That's an example of judicial review. Another example that's fairly famous, it's not very recent now, but in the last 45 to 50 years, was the Roe versus Wade decision in 1973, where the Texas abortion law that banned, I believe, almost all abortions was challenged. And in the Roe versus Wade decision, that and all other state laws that banned abortion too much in the view of the Supreme Court were overturned, or nullified. They're gone, right? And the Supreme Court then set out in Roe versus Wade how a state could regulate abortion. It could not do it very much in the first trimester, a little bit more in the second trimester, and more so in the third trimester. And even that case, Roe versus Wade, has been replaced by Planned Parenthood versus Casey in the 1990s. Okay, and so that's another example of judicial review. Okay, Another example, more recent and in everybody's lifetime in the class, is the 2015 Obergefell decision, okay, where the Supreme Court took up the question of whether states could ban gay marriage, okay, same-sex marriage, and that the court decided 5-4 that that states could not. That the 14th Amendment's Equal Protection Clause guaranteed that any two people, no matter their sex, could get married. All right, and so those are examples of judicial review. Not surprisingly, it's a power that leads to a lot of controversy. Sometimes it seems that people like judicial review when it comes out as something they agree with, and they don't like it when it comes out with something they disagree with. But it's also controversial because it does overturn laws that are passed by elected officials. And so sometimes people really get upset about unelected judges doing things. And it's a big question for the American system. In my view, who cares, I guess, right, what I say about that. In my view about it, there's a lot of scholars who you could get better considered opinions from on this. But in my view, the power of judicial review seems to be correct from the Constitution. How would you apply the Constitution? How would the Constitution be really governing what government does if you don't have somewhere to apply it? Even if sometimes the Supreme Court does, make mistakes or do controversial things or things I disagree with, there has to be some kind of umpire, to use Chief Justice Roberts' analogy here. But others would say, no, it's something that the Supreme Court took on to itself, and that courts become too powerful. And that's an argument too. That there are other ways to make the Constitution apply than to have judges who are, after all, not elected to make those calls. Now, there are a lot of controversies about how to actually interpret the Constitution. We'll get into those later when we're more looking at the judicial branch. But I wanted to make this topic here of judicial review right at the front so you can understand how the Supreme Court plays a role in saying what that federal relationship between the states and the federal national government is.